A marketing assistant notices something feels off at work. At first, it is small things, a missed bonus, a sudden change in tone from management, being left out of meetings that she used to attend. Then it escalates. A formal warning arrives. Performance is suddenly not meeting expectations. She starts questioning whether she is being pushed out. She hesitates. She thinks, maybe I am overreacting. Maybe I should wait and see. And that hesitation is exactly where many people go wrong. So let's talk about the question most employees ask too late. When should you actually contact an employment solicitor? The simple answer is this: much earlier than most people think. Now, that does not mean every workplace issue needs legal action. But early advice is often about understanding your position, not starting a dispute. Let's start with one of the clearest warning signs. If you have been invited to a disciplinary or capability process, that is a key moment to seek advice. We recently advised an employee who attended a disciplinary hearing without any legal guidance. They assumed it was just an informal chat. It was not. The outcome was dismissal. With early advice, the approach could have been very different. Another important trigger is when something changes at work without explanation. A sudden drop in responsibilities. Being moved to a different role. New criticism after years of positive reviews. These shifts can sometimes indicate underlying issues such as performance management or even potential discrimination concerns. Now let's talk about something people often ignore: your health. If work is affecting your mental or physical well-being, that is a point where legal advice can be extremely valuable. Not because every stressful job leads to a claim, but because employers have legal duties around health and safety and, in some cases, disability adjustments. We have seen cases where employees were signed off with stress for months before finally seeking advice. By that point, key decisions had already been made by the employer. Another key moment is before you resign. This is a big one. Many employees resign in frustration, thinking it strengthens their position. But resignation can significantly limit legal options unless there is a strong case of constructive dismissal. Getting advice before you hand in your notice can completely change your options. Settlement agreements are another crucial point. If your employer offers you money to leave, it may sound straightforward, but these agreements often involve waiving legal claims. That is why independent legal advice is not just recommended, it is usually required. We often see employees surprised at what they are actually signing away. Now here's something a lot of people don't realize. You don't need to be in a serious dispute to speak to a solicitor. Sometimes advice is simply about understanding your rights, checking whether your employer is acting fairly, or deciding how to respond to a situation. Early advice can prevent problems from escalating. So what should you do if you are unsure? First, start documenting what is happening at work. Keep emails, notes, and key dates. Second, do not rush major decisions like resignation or signing agreements without understanding the consequences. And third, if something feels wrong, even if you cannot fully explain why, it is worth getting clarity. At Blackstone Solicitors, based in England, we help employees understand their rights early, navigate workplace disputes, and make informed decisions before issues escalate. Because in employment law, the best time to get advice is usually before things go wrong, not after.